Hello everyone, how things going? As is, let's see here. We're going to be going over the Akins v. Knight case out of the 8th Circuit. The one case that seems to get constantly misinterpreted, misunderstood, because people say, oh, it stops, in the 8th Circuit you don't have the right to film police. Well, it's not quite as much as people think it is to be. There's a lot of misinterpreted information and understanding about this case. So, let us go ahead and start diving into that. Let me get my chat thing back up here. And actually, no, it was way before the stream even started when I was actually getting my hair fixed up and getting the beard because it was all a mess. Let's see, is that the case says filming police for personal use and not for publication is not protected in the... There's no speech or exchange of ideas. Well, it's 7th or 8th Circuit. Troy, this is the case that has been... people keep saying it is that, but it's not in reality. Had to drop from Twitch, stream a little blotchy for me there. Cheers, buddy. Yeah, sometimes it's... how should I put it? This is part of the reason why I have like the multi-streaming kind of setup. If something's going on with one of the platforms, you're able to hop onto the other one, and hopefully it'll be a lot better there. But let us go ahead and let me get the window pulled up here. And we're listening to This Is My City, Synthwave by TechnoX. Let's see here. Window capture. Here we go. We can transition this. Let me move my... There we go. I can see that now. And I did a write-up on this on Am I Free to Go 7 months ago. It's been archived now because it's been out for a while. And I sat down and did a major reading. But the basic gist of it, let's take a look at 2 videos where this case has been cited and misused.
Turn it off. No, don't. Turn the camera off. A Supreme Court of the United States released a hearing the other day says that you cannot lawfully record law enforcement. Turn the camera off. Will you? I'll show you a case law with it in just a minute if you like, okay?
Okay.
Hear what's going on and I'll...
Okay, now, this happened in August 2017, and pretty much the officer is saying, oh, there is a SCOTUS case law and all that stuff. And Bama Camera did a great follow-up on this specific incident because this wasn't even in the 8th Circuit. And it was poor misinformation that went out to the officers in the first place on it. So this way you can sort of get an idea. The police just don't fully understand some of this stuff. And here's another video.
Just so you know, the Supreme Court just ruled that you no longer have the right to videotape us when we're doing our job.
That's a different ruling. My civil rights lawyer said I could.
How long ago was that? This ruling just came out 2 weeks ago.
I called him and asked him about it. He said that doesn't pertain to police on their duties.
That's exactly what it pertained to.
No.
So, just so you know, you might watch yourself. Have a safe day.
As you can see, police were using it as soon as this case, well, this came out in the 8th Circuit. You had police sitting there trying to use it to intimidate people and misusing this case law. And a part of it sort of comes out from this article here. 8th Circuit, citizens do not have the right to film public officials in public. And we're going to go ahead and read through the entire case law. I'm going to give, well, the entire case. And I'm going to give my opinion and my take about it and inform why people are so wrong about this. In a free speech, this is 13 KRCG over in Jefferson City. In a free speech ruling that contradicts 6 other federal circuits, courts in the 8th Circuit Court of Appeals has upheld district rulings saying that Americans do not have a First Amendment right to videotape police or any public official in public. The Court of Appeals filed the opinion July 25th. The case stemmed from a lawsuit brought by Matthew Akins of Columbia, who had numerous run-ins with police as he attempted to videotape them pulling cars over and making arrests. Akins was typically standing on a public property such as street or sidewalk while videotaping encounters. Akins was videotaping the encounters on behalf of group called Citizens for Justice, which he founded in 2010. According to his lawyer, Stephen Wise of Columbia, Akins was threatened numerous times for his actions. His employer was hassled, and he was ordered to stop videotaping by police on several occasions. He had charges filed against him, many of which were later dropped, according to the 8th Circuit Court ruling. Atkins sued the Boone County prosecutor Dan Knight and several Columbia police officers, citing violations for his First, Second, Fourth, and 13th Amendment rights. Judge Nathan Lungry ruled that Atkins, by extension, any citizen or press, has no right to record the activities of public officials on public property. The 8th Circuit affirmed this ruling, and this is actually where the, how should I put it, the misinterpretation of what is being said right here, because they state, record activities of public officials on public property. I will explain a little bit further in when we start reading the actual case law. Wise has filed a motion for the 8th Circuit Court to reconsider its ruling. If it refuses, Wise said he will petition the U.S. Supreme Court to hear an appeal the ruling this fall. He said that right now, the seven states of the 8th Circuit do not have the same First Amendment rights that all citizens enjoy. The First Amendment is a core value, he said. The right to free speech and free press are central to our liberty and our ability to hold our government accountable. National Press Photographers Association took an exception to the story, posting it to their website. The 8th Circuit ruled on this case, but not on the right to record police in public. On 8/2/2016, the lower federal court only found that plaintiff has no constitutional right to videotape any police proceedings he wishes to. She also cited in 2004 8th Circuit case holding that neither the public nor the media has a First Amendment right to videotape, photograph, or make audio recordings of government proceedings that are by law open to the public. Emphasis added. This is far from different to the right to record police performing their official duties in a traditional public forum, street, or park, and only applies to the jurisdiction of the federal trial court, not the full 8th Circuit. Atkins is now seeking an end-back review of or motion for rehearing of the 725-27 8th Circuit ruling, which basically dealt with affirming the lower court's decision to grant summary judgment to the defendants, and also affirming the denial by court judge of the motion for her to recuse herself from the case. The 1st, 3rd, 5th, 7th, 9th, and 11th Circuits have all ruled that the right to record police officers performing their duties in a public place are clearly established, which negate the claim of qualified immunity by police. Columbia City Councilor Nancy Thompson says the original district court ruling has nothing to do with public right to film public officials, such as the police. However, she declined to comment further because the case is still pending. KRCG stands by the facts of this story, because actually they had to make a revision with this back when they published it, when the group, which was it National Press Photographers Association, voiced an objection to what they stated in this. And we also sort of had that over here, and we'll go ahead and read through this here, and we're going to hop into the thing, because you're getting an idea of just what the press, well, how, not the press, but everybody that's been stating about this, various media personalities on this issue. Let me move my chat thing just a little bit more over here. Here we go. And this was published August 11, 2017. Photojournalists have been on a hot winning streak before the federal courts lately, with two favorable rulings reinforcing the right to record police activity in public spaces. So there was a ripple of discontent when a regional appeals court in St. Louis handed down a constitutional clunker in the case of citizen activists suing the city of Columbia, Missouri, for interfering with his photography. But legally, there is less to the case of Matthew Stephen Atkins than initially feared. and the ruling does not harm the unbroken consensus that journalists may freely photograph or videotape law enforcement officers conducting official business. On July 25th, the 8th Circuit U.S. Court of Appeals summarily upheld without decision an August 2016 ruling from the West District of Missouri dismissing Akins' First Amendment claims. Akins sued the City of Columbia, its police department, and individual law enforcement officials in May 2015 for what it alleged was a pattern of retaliatory arrests, harassment, and confiscation of property motivated by police watchdog activism. U.S. District Court District Judge Nanette K. Lafferty threw out his constitutional claims, ruling that, in part, that a citizen has no constitutional right to videotape any public proceedings he wishes. The appeals court did not discuss the substance of the lower court ruling, but simply found no legal basis to reverse it. The Akins ruling does nothing to disturb or contradict the unbroken string of federal appeals court rulings vindicating the constitutional right of anyone, citizens as well as journalists, to capture video, images, and audio of law enforcement officers where they conduct official business in places visible to the public. Most recently, federal appeals courts in Philadelphia, Fields v. City of Philadelphia, and New Orleans, Turner v. Driver, upheld the right to bring constitutional claims against police agencies that interfere with audio or video recording of their officers. That makes 4 out of 12 regional appellate courts to affirm the right. The recording police activity is constitutionally protected. None has squarely ruled otherwise. Although Akins' lawyers were quoted describing the case as a deviation from the line of precedent, a position that would help their cause in obtaining a U.S. Supreme Court review, there are decisive factual differences. According to the district court ruling, Akins was prevented from filming a member of the public, not a police officer. In the police department lobby, specifically a citizen activist who was at the department to file a complaint. The First Amendment right to record law enforcement activity rests on the enormous power that police exercise and need to maintain, need to monitor how they use it. There is less compelling argument for the ability to film the complaint intake process inside the police headquarters. A greater concern in that space, unlike a street corner, for both the police department's ability to function and the public's willingness to use the complaint process. Imagine the potential for intimidation if the union defending police officers insisted on a right to film aggravated citizens as they file a complaints. For these reasons, the 8th Circuit perfectionary ruling does not represent a retreat from the precedent elsewhere. Rather, it simply reiterates a long-standing precedent that there is no generalized First Amendment right to be present where news is happening. Nevertheless, the Akins ruling is discouraging because once the courts begin to recognize First Amendment right to record police, it at least opened the door to establishing a broader right to access to record their official proceedings. The 8th Circuit has pulled that door shut. Though in more sympathetic future case with a working journalist as a plaintiff, perhaps a judge might persuade to reopen it. The First Amendment should be understood to protect not just the right to distribute news, but the right to gather it, without which the right to publish has diminished value. Now, you sort of get a better idea of what's in the case, where they mention that this isn't specifically filming on a public street. This is dealing with filming inside a police department. And a good reason also why I'm talking about this is back in February, the Supreme Court has refused to hear this case or even look at it. You can see that on the Black Coat Media website, blackcoatmedia.org. That's in the description of this live stream if you want to go check it out. Yes, and yeah, way too early for some people. I woke up, I couldn't fall back asleep. I'm like, you know what? I've been needing to do this. I'm going to go ahead and do this. So, as is, let's see here. We're going to go ahead and get into the nitty-gritty here. Let me drink my energy drink of sugar which helps me do this. The United States Court of Appeals, out of the 8th Circuit. Plaintiff, Akins, defendant, a bunch of police officers and stuff like that. All right. Well, at least this is not too long of a thing. It's only 6 pages. But all the citations that are gonna that need to be covered is gonna make this a really long stream. Kareem. Okay, I'm screwing up pronunciations again. Over a period of years, Matthew Akins had numerous encounters with the police officers in Columbia, Missouri, and in 2015, Akins filed a lawsuit under 42 U.S.C. 1983. The defendants are 5 police officers, their prosecutors, the City of Columbia, and the Boone County collectively as the defendants. Akins alleges numerous violations of his constitutional rights arising from these encounters. The district court granted a motion to dismiss by some of the defendants and a motion for summary judgment by others. The court also denied Akins' motion for pre-trial summary judgment and 2 motions seeking recusal of a judge assigned to his case. Akins appeals, and we affirm. And between 2010 and 2013, Matthew Akins had many encounters with law enforcement officers who worked for the Columbia Police Department, CPD, in Columbia, Missouri. Some of these interactions resulted in charges filed against Akins by prosecutors from Boone County, Missouri. Many were subsequently dismissed. Akins suggests that he was targeted by police and prosecutors in part because he had been working to document and report on police conduct through a group called Citizens for Justice, CFJ, which he had formed in 2010. It's pronounced per curiam. Okay, per curiam. Thank you, Real Jingy. In 2015, Akins filed this lawsuit under 42 U.S.C. 1983, alleging that his constitutional rights under the 1st, 2nd, 4th, and 14th Amendment had been violated by the defendants. Among other matters, Akins alleged that his rights had been violated by 1 stop at a sobriety checkpoint in May 2010, resulting in his being arrested, and 2, a stop for a traffic violation in June 2010, resulting in Akins being removed from his vehicle and handcuffed while his vehicle was searched. Akins also alleged the defendants violated his rights by removing videos he had posted on CPD Facebook page, by ordering him to stop filming the filing of a citizen complaint in CPD lobby, by posing in the police department a flyer with information about him. And there's one citation right there. Shortly after initiating this lawsuit, Akins filed a motion to seek recusal of the district court judge assigned to the case. The district court denied the motion. Thereafter, the court granted a motion to dismiss filed by Boone County and the individual prosecutor defendants. A request for reconsideration of that decision by Akins was denied. He then filed a second recusal motion, which was also denied. The individual police officers, defendants in the City of Columbia, subsequently moved for summary judgment, and Akins moved for partial summary judgment. The court granted the defendant's motion, but denied that of Akins. On appeal, Akins argues the district court erred by failing to recuse herself by granting a defendant's motion to dismiss for summary judgment. We first consider the district court's denial of Akins' recusal for motions for turning to the motions to dismiss and for summary judgment. Had to burp there as I drink more soda to help add more bubbles. Okay, continue on. Akins argues that the district court erred by not transferring his recusal motions to another judge and her denying them herself. Motions to recuse may be based on either of 2 federal statutes, 28 U.S.C. 144 and 455. But under either statute, the standard is the same. Recusal is required if the judge bears a bias or prejudice that might call into question his or her impartiality, citing United States v. Gamboa of the 8th Circuit, 2006. We review recusal decisions for abuse of discretion, United States v. Larson, 8th Circuit, 2005. Akins first argues that the district judge erred by ruling on his recusal motions herself, instead of assigning those motions to another judge for disposition. In support of his argument, he quotes 28 U.S.C. 144, which provides in relevant part, whenever a party to a proceeding in a district court and files a timely sufficient affidavit that the judge before whom the matter is pending is a personal bias or prejudice either against him or in favor of any adverse party, which such judge shall proceed no further therein, but another judge shall be assigned to hear such proceedings. Akins argues that by failing to assign the recusal motion to another judge for disposition, the district court violated the statute's mandate that another judge should be assigned to hear the proceeding which affidavit of bias has been filed. Akins' arguments is without merit. Taken in a whole, the plain text of 144 mandates only that district court judge ensures that another judge is assigned to any case in which a litigant has sufficiently alleged bias or prejudice, not that the recusal decision itself be rendered by a judge other than a judge to whom the motion is addressed. Our court, as well as others, have routinely affirmed the recusal decisions rendered by a judge against whom the motion is directed. See United States v. Johnson, 8th Circuit, 2016. See also Doty v. Oxy USA Incorporated, 5th Circuit, 1996. Let's see. Statements, counsel, and brief argument are not facts before the court and therefore insufficient for motion to dismiss or for summary judgment. Thank you for the quick rundown on that, Real Jingy. If the issue of the judge recusing herself arises either through motion to recuse under 455, the affidavit of prejudice under 28 U.S.C. 144, or the judge's own motion, the judge may, at her option, transfer the matter to another judge for decision or determine it herself. For these reasons, we reject Akins' argument that the district court erred by failing to transfer his recusal motion to another judge for discussion. Akins also contends that the district court erred by denying his motions to recuse on their merits. In opening brief, Akins argues the recusal was warranted because 1. The husband of the judge assigned to the case is the chair of the mayoral task force for the defendant city of Columbia. 2. Evidence relevant to the Akins case included a video report he made that was critical of the judge's action in a different case. 3. His attorney once filed a judicial complaint against a judge in an unrelated matter. And 4. The judge was formerly a municipal judge for the defendant city of Columbia. The district court did not abuse its discretion when it decided none of these facts singly or in combination would provide an objective, knowledgeable member of the public with a reasonable basis for doubting the judge's impartiality. First, although the judge's husband is connected with to one of the defendants, Akins has not alleged that relationship between the judge's husband and defendant is a kind that necessitates recusal. See 28 U.S.C. 45, B, 4, and 5, mandating recusal when a judge's spouse is an officer, director, trustee, or party, or where her spouse has an interest that could substantially affect the outcome of the proceeding, among other things. The mayoral task force chaired by the judge's husband has no discernible relationship to this case, nor is the topic being addressed by a task force at all implicit here. Under the circumstances, a disinterested member of the public would not think the judge's husband's association with the defendant's calls to into question the impartiality. C.F. Sinsley v. Arbitration, 5th Circuit, 2004, noting that a relative's mere at-will employment relationship with an agency or law firm representing a party before a district court judge in a particular case is insufficient to require a judge to recuse himself. Hewlett-Packard Corporation v. Bouchard and Lom Incorporated, federal case 1989, determining recusal not necessary in a case where a judge's son was employed by a party. Second, the fact that Akins produced a report critical of the judge's ruling in a prior case does not mandate recusal, even assuming that Akins' report would have been dismissed, been admissible evidence in this case. We have previously held that a litigant's personal attacks on a judge do not necessarily require recusal. See Isaac Sun v. Manti, 8th Circuit, 2013. Moreover, other court of appeals have noted that a rule that would require recusal anytime a litigant has been critical of a judge would create perverse incentives and enable judge shopping. See United States v. Owens out of the 4th Circuit, 1990. Parties cannot be allowed to create a basis for recusal by their own deliberate actions. Finally, the third and fourth points Akins raises that the judge could not be impartial because she was once a municipal judge for the defendant City of Columbia, and because Akins' attorney filed for a judicial complaint against her in a previous case, were raised by Akins' counsel and rejected by our court in another case. See Roger v. Knight, 8th Circuit, 2015. These points thus also failed to establish the court judge should have recused herself in this case. We therefore conclude that the court district did not abuse its discretion in denying Akins' motion to recuse. Now, as we can see in this first part, that this is it covers the issue of motions that were filed in the case, and they cite several case laws, not just within their own circuit and outside of that circuit, that backs up their decision that that motion for recusal doesn't have to play out the way that the Akins lawyers want it to play out. And they also make a very good case here. With the United States v. Owens out of the 4th Circuit, parties cannot be allowed to create basis for recusal by their own deliberate actions. Because if you sit there and you start making critical videos about the various judges, you're going to try to forcefully narrow it down to where you get the judge that you want. And that could be easily detrimental into the whole legal proceedings in some aspects. The whole idea about going to court, especially if you have a judge, is to have as an impartial judge as possible for that situation. But as is, we get an idea, at least for the first part. Now, we're going to get into the good part of, well, I think this covers, wait. Wasn't there more to this? Akins also argues the district court erred. I could have swore there was more on this page. Okay, this is messed up because there's more on this than just... Okay, Akins also argues the district court erred by granting the motions to dismiss and for summary judgment filed by the defendants and by denying his own motion for partial summary judgment. After careful de novo review, Letterman v. Doe's 8th Circuit summary judgment stands. Gomez v. Wells Fargo, 8th Circuit 2012 motion to dismiss standard. We conclude that the district court did not err in its thorough and well-reasoned opinions. Accordingly, we affirm the 8th Circuit for the reasons that we affirm. And maybe I pulled up the wrong one. I thought there was more pages on this because I remember reading through a huge amount. Oh wait. That's why. Wait, is this it? No, this is the first round because it's page 55. Let's see. Citations refer to district court cases. Oh. Never mind. Okay, that's right. I ended up reading this. So this was the appeals case that just... what it did is reaffirm the standing motions. And then this here is the actual court case here. It took me a minute here, to get my memory back into place here. Because I ended up reading this back in... 7 months ago, so I easily forget. And I only did some minor touch-ups or reviews of this. But... let us go ahead and read through, this one here. and get an idea specifically on what was decided in the district court level. Plaintiff Matthew Stephen Akins alleges that the defendant violated federal and state laws in connection with various stops and arrests of him between May 10th and May 2013. At the time of the alleged incidents, defendant Kenneth Burton was the chief of the city of Columbia, Missouri Police Department, and defendants Eric Hughes, Rob Sanders, Roger Schlude or something like that, and Michael Palmer. I think that's Michael Palmer. Were City of Columbia police officers. Akins complains of his May 9th, 2010 arrest and seizure of his gun, a June 2010 traffic stop, a July 27th of 2011 incident at Taco Bell parking lot, his September 11th, 2012 arrest and seizure of his butterfly knife, a poster of him that was displayed in the police department briefing room, and other incidents involving alleged retaliation, failure to train, and malicious prosecution and a conspiracy. The defendants Burton, Hughes, and Sanders, Schlude, Palmer, and the City of Columbia moved for summary judgment, docket 81, on all claims. Akins moves for summary judgment in part. In part. Defendant's motion for summary judgment is granted, and Akins' motion for summary judgment is denied. Background. May 9, 2010 incident, Officer Hughes, the arrest. On May 9, 2010, Hughes stopped Akins on a routine DUI checkpoint in Columbia. Akins was driving a 1997 Toyota Camry, and Hughes did not know who Akins was at the time of the stop. I got a burp here. Come on. Okay. When Hughes was speaking with Akins, he observed Akins' eyes were bloodshot and his hands shook. As he handed Hughes his documents. Hughes also smelled what he believed to be smell of marijuana. Hughes asked Akins to step out of the car. Akins began rolling up his window, at which point Hughes opened the door for himself and asked Akins to step out, which Akins did. As Akins stepped out, Hughes saw Akins move his right hand close to his leg and quickly place an unknown item in his right pants pockets. Based on Akins' nervous demeanor and the quick motion, Hughes believed Akins could have placed a weapon in his pocket. To check Akins' pocket, he retrieved an unknown item. Hughes moved aside a paper towel, and that was Akins. Dang, I just lost myself here. Akins would step out. Hughes, based on his nervous demeanor, his weapon. To check Akins' pocket and retrieve an unknown item, Hughes moved aside a paper towel that was in Akins' pocket. Based on Hughes' training and experience, the paper towel was wrapping what Hughes felt like marijuana stems, seeds, and leaves. When Hughes patted Akins down, Hughes felt a gun near Akins' waist. The gun, a .38 revolver, was holstered and attached to Akins' belt covered by his shirt. Akins did not tell Hughes about the gun at any time before or after getting out of the car. Akins says did not tell Hughes about the... Akins says Hughes' actions from the time of the opening of the door to when he performed the pat-down did not provide reasonable time to tell Hughes about the gun. When Hughes felt the gun, Hughes pushed Akins off balance against the car and yelled, "Gun!" Hughes asked Akins whether he had a concealed carry permit. Akins said he did not, and that his attorney told him he did not need one to carry a gun in the car. Hughes later wrote in the officer's report, "The gun was discovered to be loaded with 11 bullets in the magazine and 1 round in the chamber. The gun was readily capable of immediate lethal use and was concealed under Akins' shirt, not visible to others." Docket 91-3, page 20 of 22, officer report. Akins admits the gun contained bullets, but he says there was no bullet in the chamber when Hughes removed the gun from his holster. Akins says when Hughes drew the slide back to check whether there was a round in the chamber, Hughes' action chambered around docket 91-1, page 2. Akins admits that a tissue removed from his pocket could possibly have contained remnants of marijuana or marijuana byproducts. Docket 82-1, page 14. Atkins Depot, page 56. Deposition, page 56. Another officer searched Atkins' car and located a plastic baggie under the driver's seat containing what the officers reported to be marijuana. Atkins admits he had used marijuana at home sometime, and it was possible that what the officer found in his car was his marijuana. Atkins' deposition, page 71. Hughes arrested Atkins for drug possession and lawful use of a weapon. Number 2, return of the gun. Boone County prosecutors subsequently charged Atkins with an unlawful use of a weapon, a Class D felony. Then, on November 16, 2010, the prosecutor dismissed the charges, nol prosequa, and possession of Matthew Atkins' Bessera .38 pistol was maintained by the Columbia Police Department pursuant of the recommendations of Boone County Prosecutor's Office, docket 4, page 8 of 40. In February 2012, Atkins' defense attorney emailed the assistant prosecutor who had handled the case, asking if Atkins' gun could be returned to Atkins. The assistant prosecutor responded that should be all right, and asked whether Atkins had proof of ownership. No evidence in the record shows Atkins' attorney responded to the question about proof of ownership, or the prosecutor relayed the request to the city police department. The city police department was performing a routine audit in October 2012, and according to the city, in the course of the audit, learned that it still had Atkins' gun. At the time, Atkins had pending felony charges relating to the arrest of possession of a knife. The city sent Atkins a letter 1 week later informing Atkins that there was a gun available to be picked up by a third party, as Atkins had a pending felony charge. The evidence custodian of Columbia Police Department, Michelle Heater, I think that's how you pronounce it, also explained to Atkins in a phone call on October 24, 2012, that a third party could pick it up. No third party came to get it. In February 2013, Atkins emailed Chief Burton and Boone County Prosecutor requesting return of the gun. Boone County Prosecutor Office, Prosecuting Attorney's Office notified Heater on March 20th, 2013 that they no longer needed the gun. Atkins was told on March 28, 2013 that he could pick it up at any time. He picked it up on April 15, 2013. June 6, 2010, incident and Officer Schlude. On June 6, 2010, around 6:50 p.m., Atkins made an illegal U-turn while driving, and Officer Schlude stopped him. Atkins admits that the stop was lawful. Docket 4, page 8 of 40. Atkins had 2 passengers with him, including one in the back seat. Atkins submitted the affidavit of one of his passengers, Kay Jones, who said after pulling Atkins over, Schlude asked Atkins whether there was any illegal drugs or weapons in the car. Docket 91-7, Jones affidavit. Atkins told Schlude that there was a illegal rifle on the rear floorboard. Schlude does not have an independent recollection of the interaction with Atkins. The dispatch system records reflect that Schlude would have been advised at the time that Atkins had a Type 2 indicator, meaning Atkins was known to be armed and violent, and that Atkins' passenger had a Type 1 indicator, meaning that they were known to be violent. Atkins also had a felony weapons charge at the time. According to dispatch records, Schlude told dispatch that there was a rifle in the car and requested backup. Schlude said that based on the facts in the dispatch record, he would have approached the situation with caution given Atkins was known to be armed and violent, with 2 individuals were known to be violent, and that there was a rifle in the car. Schlude also ordered Atkins and the 2 passengers out of the car. All 3 were handcuffed and searched by a second officer who arrived at the scene. Jones says the second officer was searching them for dangerous objects. The 3 were directed to sit on the curb while Schlude searched the car. Atkins did not consent to the search. Atkins says Schlude moved some items out of the car during the search, and the entire encounter lasted 20 to 30 minutes. Schlude issued Atkins a citation for an illegal turn. Atkins says he asked Schlude whether he had done anything wrong with the gun and what the protocol was for the situation, like the one he had just found himself in. Docket 91-1, page 5, Atkins affidavit. He says Schlude responded that that it depended on the officer, i.e., some would see the gun in the car, pull their own gun, and shoot him dead, then testify they had feared for their life, and charge would be dismissed. Officer Sanders was patrolling in moving on to the July 27, 2001. Actually, no, let's comment on this one. Quite interesting, if this is true, which I don't have, I would say it's very plausible. An officer would probably end up doing that. They would just, they see gun, shoot, and then claim they feared for their life, despite it being on the floorboard. So just keep this in mind. You do got officers that are quick trigger. Anyway, moving on to C. July 27, 2011 incident and Officer Sanders. Officer Sanders was patrolling in Columbia on the night of July 27, 2011, when he saw a car and exit what he considered a high-crime neighborhood. Sanders began following it and observed that the occupants became animated, and the driver began behaving differently once the driver noticed him following. Engaging in what Sanders' training and experience had taught him were avoidance techniques, i.e. changing lanes multiple times and turning into a parking lot. According to Sanders' training and experience, that behavior indicates the occupants were trying to avoid contact with the police. Atkins was the driver, and he admits that he noticed a police car behind him, docket 92, page 447, although he did not know at the time it was Sanders. Document 82-1, page 38, 36 of 88, Atkins deposition. Atkins admits that he was driving. He deliberately changed lanes 2 separate times to determine if they were being followed by the police car. And both times, the police mirrored Atkins' lane changes. Docket 92, page 447. Atkins' passenger M. Carter retrieved video camera and began recording events as they unfolded. Sanders contacted Joint Commissions, and he recited a license plate number and was given the name, and asked for priors. They stated he was going to try and check on the vehicle here, probably at Taco Bell. Docket 82-40. Let's see, audio recording. Joint Communications checked whether there was units to assist. Officer Scott Hendrick and Mike Parson responded that they were close. Atkins went to the drive-thru and ordered food. Sanders followed Atkins' car, and while Atkins was waiting, Carter turned around and continued filming out the back window. Sanders saw the camera light shine at him and wave. Sanders had recently been trained individuals who use phones or cameras to video police to try to deter contact by officers. Wait, what? Okay. Sanders had recently been trained that individuals will use phones or cameras to video police to try to deter contact by officers. Quite often, I see it work the opposite way around. It's like moths to the flame. You pull out the camera, all of a sudden their focus is on the camera. Ooh, shiny camera. I had to interrupt on that one. Sanders parked in the Taco Bell lot. Atkins got his order under a order and pulled into an open parking spot in the Taco Bell lot. Sanders saw occupants begin to watch his patrol car. Officer Hendricks and Parsons pulled into the lot, driving a K9 unit. Sanders had not asked for a K9 unit. No evidence in the records reflects Sanders told Hendricks and Parsons where to park. Sanders never activated his lights or sirens. There was no evidence that his car was parked in such a way to block Atkins' car. Sanders walked to Atkins' driver's side window. After the greetings were exchanged, Sanders asked Atkins, "You got a driver's license I could see?" Atkins asked Sanders what his probable cause was, and Sanders replied, "I don't have probable cause." Atkins also asked Sanders if he was conducting a traffic stop, and Sanders said he was not. Sanders asked Carter if he had identification. Carter indicated he did, and Sanders asked if he could please see it. Sanders also asked whose car Atkins was driving, and Atkins said it was his mother's. Atkins and Carter gave Sanders their identification, and Atkins said to Sanders that he believed he was responding to an order by a law enforcement officer rather than a casual request. Sanders said, "All right, sit tight, guys." So it looks like they pulled some verbal judo here. and they got him to go ahead and give up his ID when there wasn't an actual traffic stop. The officer is trying to say it was a consensual conversation, but yet they managed to get their ID off of them, and Akins thought that was actually being a detainment. Officer Hendrick told Officer Parson to get his dog out of the car, but to stay back. Officer Parson did so, to introduce the dog to new things, new sights, sounds, and trying to get him to be used to being a police dog. Sanders did not tell him to take the dog out of the car or otherwise tell him to where to stand or how to handle the dog. Officer Hendrick went to the passenger side window of Atkins' car. Hendrick said that to Atkins that Sanders was just checking you, that he and Parsons happened to be in the area, and said it was just a safety issue. Hendrick and Parsons never drew their weapon or activated their patrol car lights or sirens. Sanders contacted Joint Communications again, and he said, I'm at a check subject at Taco Bell, at Providence and Loop, unintelligible. I see about name and date, docket 108-9, audio recording. Joint Communication asks, which do you want, a traffic stop or on a different check subject? Sanders responded, it's the same incident, but it's not a traffic stop. I'm without license plate number, but it's not a car stop. 1 minute later, in the recording, Sanders gives Joint Communications Atkins and Carter's names and birth dates to run. Sanders later asked Joint Communications whether it could add to the registration that the subjects were Columbia citizens on patrol. Sanders returned to Atkins' car after what Atkins says no more than 1 minute and 30 seconds. Returned the identification, told Atkins and Carter they were free to go, and thanked them for their cooperation. Sanders then pointed out an open beer bottle on the floor of the car. Atkins said his mother's and Sanders offered to throw it away. So he was free to go. I'm sort of now questioning the entire stop here myself, just with this part of the statement. Hey, China Lynn. We're finally going over that 8th Circuit case. We're looking at the district side of things. We already covered the 8th Circuit ruling, but we're looking at the more specific parts. Sanders contacted Joint Commissions again, and he said he would be out report writing unless assistance was needed. Joint Communications said negative and asked, what did you find about your check subject at Taco Bell? Sanders said he tried to clear it himself, but the computer probably crashed and asked it to be shown as clear, no report. A Columbia Police Department Internal Affairs investigation concluded the incident at Taco Bell was a detention, rather consensual contact under all circumstances, and that Sanders had violated a police department guidelines concerning seizure of a person within the limits of the Fourth Amendment interpreted by the judiciary. So there was an internal complaint filed here, and they found that this stop was improperly conducted. Seems quite interesting. September 11th, 2012, incident in Officer Palmer. On September 11th, 2012, Officer Palmer stopped Akins, who was driving a white Kia, after Akins failed to yield a right-of-way at a four-way stop, and when Palmer was already in the intersection. At the time he stopped the Kia, Palmer did not know who was driving. Akins could not produce a driver's license, but he told Palmer that he was driving to a Citizens for Justice related event and was therefore covered to drive under his limited driving privilege, docket 91-1, page 12 of 16 of Atkins' affidavit. Palmer told another officer who arrived at the scene to assist that Akins was with Citizens for Justice. When Palmer ran Atkins' name through the mule system, Atkins' driving privilege was reported as revoked without any limited privilege. Atkins could not provide proof of insurance. Palmer's arrested Atkins for driving while revoked, failure to yield right of way, and failure to maintain financial responsibility. See, guys, yeah, you definitely don't want to be driving around without insurance. So just keep that in mind. In conducting a search incident to arrest, Palmer found a butterfly knife in Atkins' right front pants pocket. Based on his training and experience, Palmer knew butterfly knife was a type of knife which had the handle, which the handle is hollow and split in two parts, and connects the back of the blade with two loose pins. To open a butterfly knife, the blade pivots around the pins in an arc. Based on his training at the police academy, knowledge, and experience, Palmer knows that a butterfly knife can be opened one-handed by the operation of gravity or application of centrifugal force. Docket 82-32, page 2 of 4, Palmer affidavit. The sharp part of the butterfly knife edge was about 3.5 inches long, measured from the tip to the hinges. The blade is 4 inches long. In addition to driving and insurance violations, Palmer also arrested Akins for unlawful use of a weapon in possession of a prohibited weapon under Missouri Revised Statute 571.020 and 571.030. Prior to submitting the probable cause statement, Palmer checked with supervisor about the butterfly knife. The supervisor told Palmer the knife was illegal. Palmer wrote in probable cause statement that the knife was designed to be opened from the handle by gravity or by the application of centrifugal force. Sounds like the Internal Affairs probably just told the officer to document the stop next time. Yeah, it's hard to say. We don't have access to all those papers. I would probably have to get the parser thing up, and that would be a lot more digging up and going. That reminds me, I gotta get my parser account redone. Akins continued his reporting activity for months following the September 11, 2012 encounter with Officer Palmer. In May of 2013, the charges were amended to driving while revoked or suspended and failure to yield of right-of-way. Lots in this case. Akins poster in Citizens for Justice website. Prior to the creation of Citizens for Justice website, Akins had at least 9 contacts with police, with the Columbia Police Department that had resulted in his arrest. He began construction of the website in June 2010, and the Columbia Police Department became aware of it in December 2010. The website concerned law enforcement interactions with the public, including alleged police misconduct by the Columbia Police Department. Akins Systems Administrator accidentally erased the website in fall or winter of 2012. Docket 82-1, page 106, Akins deposition 261-62. But Akins says Citizens for Justice is still active, still has an active YouTube and Facebook pages. Docket 104, page 30. At some point in 2011, a poster concerning Akins was put up in the police department's briefing room, an area not generally open to the public. No evidence in the record shows who created or put up the poster. The poster had a photograph of Akins. It stated he drove a silver Pontiac Grand Prix and had arrests in the system for weapons violations, including carrying a pistol concealed on his person. Akins also stated Akins ran a website and gave a website address, which was for Citizens for Justice, docket 82-21. The police department does not have a policy concerning posters being displayed within the department. At the time the poster was up, Akins was approaching police officers at night while they were responding to calls and otherwise performing their duties, recording the officers' activities with a camera in night vision mode, and displayed an illuminated red dot when it was on. Docket 82-29, defendant's affidavit, and then several other things. Chief Burton opined on this poster promoted Akins and officer safety. At some point, Akins began filming police officers. Chief Burton, or Jill Schlude, advised the police department that Akins had the right to film. Docket 82-29. Other incidents. On May 19, 2010, Akins was pulled over by Columbia police officer Thomas Quantina to check the window tint for expired plates. Akins was arrested pursuant to 2 active arrest warrants. Email and meeting with Chief Burton in December 2011. Chief Burton had Akins in his personal email address. They exchanged emails. On December 6, 2011, Akins wrote in an email to Burton, "Although I was skeptical when you first became chief and at certain times during your tenure, I have come to respect you, and after living through the Randy Boham administration, know it could be a lot worse. All in all, I appreciate what you're doing and wanted to tell you to keep it up. Atkins also met with Chief Burton in December 2011. Burton told Atkins it was his right to film officers. Burton also said it was his goal to put them out of business in the context that I hoped there would be no negative actions of the officers to film. Burton was also aware that some of the officers thought Atkins should not be filming, but did not recall any specifics. Docket 92-6, public, interrogations of to the Chief Burton. October 14th, 2011. Incident and Officer Hughes. Akins was in a Columbia bar, Salty's, on October 14th, 2011. At or after the 1:30 a.m. closing time, Officer Hughes was on patrol in the area. Hughes used his patrol car spotlight to illuminate the interior of the bar to see people who were still there. A standard procedure for Columbia Police in 2011 that had been adopted from the Lincoln, Nebraska Police Department. Columbia Police had found people loitering in and around bars after closing time, and often led to fistfights and other peace disturbances. So had adopted the procedure to encourage patrons to leave bars after closing time and avoid loitering around them. The police officers also used spotlights in 2011 to identify individuals and to gain visibility at night, because intoxicated persons were often walking the streets. Numerous people were leaving Salty's after 1:30 a.m. on October 14, 2011. Atkins was filming from inside the bar. Hughes approached a bar employee and told him everyone had to be out of the bar, or the bar would be fined for having patrons inside after 1:30. Atkins was working there as a videographer. No evidence in the record shows Hughes knew Atkins was a bar employee when Hughes approached the bar's employee. Atkins walked up to Hughes outside the bar, and at the time, Atkins had at least one outstanding warrant, so Hughes arrested him. While Hughes was arresting Atkins, Atkins asked him for about a poster hanging in the Columbia Police Department. Hughes said he thought the poster was hung because Atkins had a warrant out for his arrest. October 16, 2011, incident in Officer Corcoran. Atkins with his brother in a crowd of people leaving Salty's bar around closing time on October 16, 2011. When Atkins claims he was singled out by Columbia police officers, Corcoran with a spotlight from the officer's police car. Atkins says, as we videotaped and we walked sideways across to an adjacent parking lot to demonstrate we were being followed by the light and in an active area crawling with people. Docket 91-1, page 11 of 16, Atkins affidavit. The filming in the police department lobby 2011, and here is where the big fun stuff comes into play. The Columbia Police Department has a lobby that is open 24 hours a day. It contains a media book, a beat map, informational brochure, a memorial to slain Columbia police officers. The media book contains copies of incident reports from prior night for interested media members. The beat map assists citizens in determining the beat they are in for purpose of filing police reports. Sometime in 2011, Atkins was filming a person who was wearing a Ku Klux Klan hood and was standing in the lobby to pick up a complaint form. A community service aide, CSA, who was not the defendant in this case, told Atkins he could not film in the lobby and to turn the camera off, which Atkins did. Atkins later followed up with the police department public information officer, Jill Schlude. Schlude told Atkins that CSA had been wrong and said that filming in the lobby was not allowed, and Atkins to stop filming. Schlude also said the police department had to follow up with the CSA so he would know that Atkins was wrong. The CSA was not disciplined for asking them to stop filming. Media Training Day. In October 2015, the police department held an invitation-only media training day for media partners, docket 100-2. The email invitation stated that due to space limitations and to provide the best experience possible, we're limiting the training to 30 participants. The invitation was extended only to traditional media members, including local television stations and newspapers. Docket 108-3, page 406, Jill Schlude's affidavit. A person who had been invited forwarded the information to Akins, who attempted to RSVP to the police department in order to attend. A police department public information officer replied to Akins, apologizing if he thought he was registered, and explaining that the event was invitation only and he had not been invited. Now, I'm going to point out the filming in the police lobby and the media training thing are the two big First Amendment issues that play the role on the aspect of filming that will be decided upon in this district court case, and pretty much isn't really upheld because, as I stated, this appeals case, and we read, this appeals case right here just deals with the motions, not the actual court case itself, not establishing any, like, case law precedent. Why do cops always got to be grand critics when it comes to bright flashing spotlights? Who knows? Maybe they're just woolies. The Columbia Police Department Facebook page. Okay. The Columbia Police Department has had a Facebook page since at least 2011. From 2011 to spring 2016, the page has always contained substantially the following statement. The purpose of this page is to provide an opportunity for the Columbia Police Department to supply information to the public about department events, crime alerts, and other important information. We encourage you to submit comments, but please note that this is not a public forum. Comments posted on this page will be monitored. The Columbia Police Department reserves the right to remove inappropriate comments. Okay, now we all know pretty much this is a bunch of load of shit of trying to stop saying that is not a public forum when we've had court rulings upheld in California and Hawaii that says it is a public forum. And we got, I think, 3 other cases that are ongoing right now that are being filed over this specific topic. But keep in mind that this was decided back in, I think, 2015. So, or was it 2015? I can't remember. I'll look it up again. Or 2016. Docket 108-3, defendant's affidavit Jill Schuh. Sometime after 2011, the department added examples to the statement. Akins states he had posted several Citizens for Justice videos on police department's website, but then in December 2011 found that his videos were no longer there and he could no longer post anything. He said that, in fact, he saw that all his posts by other outside departments had been removed. So he contacted the public information officer, Jill Schuh. Schuh told him the city did not have a formal social media policy. Administrators had decided to work on one, and until a policy was in place, the police department would be posting its own content. Schuh further explains that the approach was a city-wide one, not limited to the police department. Since the summer of 2011, no one can post original links to videos on the police department's Facebook page, and no one can post comments that do not relate to the original post by the police department. In 2011 through 2012, the comments to the pages were not related to the topic of the post under which they were made, would have been considered inappropriate, and would have been removed. This is true for all users. Schuh has also reviewed the topics posting from 2011 to 2012 and found none related to the subject of Akins' Citizens for Justice videos. While the memos concerning social media policy have been prepared and circulated, the city has not adopted a social media policy. Pennsylvania Department of Records has ruled Facebook is public. I am surprised that no one has complained to them about the comments that were deleted after pissed off the taxpayer. Oh, News Now Tennessee, do a video about that, please. Please do a video about that and let me know about it. I definitely want to know more about that. That could be your shtick right there. That could be your shtick. Discussion. Or that could be your white whale. There you go. Slaughter that white whale, man. Show us what's inside. Discussion. A movement is entitled to summary judgment if the pleadings and disposition, answers to the interrogations, and admissions on file, together with the affidavits, if any, show that there is no genuine issue as to any material that had a moving party, is entitled to judgment as a matter of law. Federal Review something 56. The plain language of the rule mandates the entry of summary judgment after adequate time of discovery upon the motion against a party who fails to make showing sufficient to establish an existence of an element essentially to that party's case, on which a party will bear the burden of proof at trial. Citations Corp. Making reference to a case out of 1986. I think this is just a district case because I don't see a circuit thing next to it. In deciding summary judgment, the court reviews evidence in light of favorable non-moving party. Nuck v. City of Park Hills out of 8th Circuit, 2002. However, non-movement must present more than a scintilla of evidence and must advance specific facts to create a genuine issue of material fact for trial. Let's see, quoting FDIC v. Bell, 8th Circuit, 1997, to survive a motion for summary judgment under 1983, the plaintiff must raise a genuine issue of material facts as to whether 1. The defendants acted under color of state law, and 2. The alleged wrongful conduct deprived the plaintiff of constitutionally protected right. Mann v. Yarl, 8th Circuit, 2007, citing Cooksey v. Boyer, out of the 8th Circuit, 2002. Further personal involvement is required in order for an individual to be liable under 1983. Beck v. Lafleur, 8th Circuit, 2001. Liability for damage for federal constitutional tort is personal, so each defendant's conduct must be independently assessed. Wilson v. North Cutton, 8th Circuit, 2006. I'm the same, China Lynn. I'm not a fan of Facebook either. I use them for pretty much just certain communications and keeping tabs on certain discussion groups, especially when it comes to like Neighborhood Watch and stuff like that, because it's just used. Otherwise, I don't really post anything on there. Probably Invictus. As I said, the only reason I have accounts on there is to deal with certain situations. And where am I at? Let me move this real fast and take a look. Man, we're not even halfway through this reading here. Further, a police officer is entitled to qualified immunity unless a plaintiff can establish that the officer's conduct violated constitutional right, and the constitutional right was so clearly established at the time of the alleged violation that a reasonable officer would have known that his conduct was unlawful. Warbell v. Hall, 8th Circuit, 2009. The court has discretion to choose which of the two aspects of qualified immunity to address. Pearson v. Callahan, 2009. Now we're going to start going through the decidings on the individual stops. Well, on the individual points that are brought up. On the May 2010 incident with Officer Hughes, Akins alleges that on May 9, 2010, he was seized by Officer Hughes without probable cause because it was lawful to carry a concealed gun in the car. Docket 4, page 6 through 8 of 40. Hughes arrested Akins for possession of an illegal substance as well as an unlawful use of a weapon. Because Hughes, at a minimum, had a probable cause to arrest Akins for possession of marijuana, Akins claims concerning the arrest for the gun fails. An officer only needs to demonstrate probable cause to carry out an arrest for any offense arising out of an incident. That the officer may have had mistaken belief that she had probable cause to an arrest for other offenses is immaterial as long as the probable cause existed for the one offense. Smith v. Aldrich, 8th Circuit, 2000. To determine whether the officer had probable cause to the arrest, the court examines the events leading up to the arrest, and then decides whether the historical facts viewed from the standpoint of an objectively reasonable police officer amount to probable cause. United States v. Winterskey, probably mispronouncing that, out of the 8th Circuit, 2010, quoting Maryland v. Pringle, 2003. I'll see also United States v. Patrick, out of the 8th Circuit, 2015, noting that probable cause is evaluated based on the totality of the circumstances at the time of the arrest, The officer need not have witnessed the actual criminal activity or collected enough evidence to justify the conviction for there to be a legitimate finding of probable cause to justify a warrantless arrest. Instead, the mere probability of substantial chance of criminal activity is all that is required. The Winskate case, citation omitted, quoting United States v. Menendez out of the 8th Circuit, 2005. Here, Hughes stopped Akins at a routine DWI checkpoint. Hughes smelled what he believed to be an odor of marijuana coming from Akins' car. Observed Akins' eyes were bloodshot, his hands were shaking, and he was acting nervously. Hughes also observed Akins make a quick movement as Akins got out of the car, placing an unknown item in his right front pants pocket. Based on Hughes' training and experience, he believed Akins were indicative of an individual who was using or possessing a controlled substance and who may have placed a weapon in his pocket in performing a search. Hughes felt what he believed to be marijuana leaves, stems, and seeds wrapped in a paper towel in Akins' pocket. In search of the vehicle turned up a baggie of what Hughes believed to be marijuana. Atkins admitted in deposition that the material may have been his marijuana. Hughes had probable cause to arrest Atkins for drug possession. Atkins' argument that the material seized was not ultimately proven to be marijuana, it was not enough to be enough marijuana to be prosecuted for under local ordinance, does not show Hughes lacked probable cause. The mere probability of substantial chance of criminal activity is all that is required. See also New v. Denver, the 8th Circuit, 2015. A police officer can have probable cause to seize whatever appears to be a controlled substance that is later to be determined to be something else. Citations therein. Because Hughes had probable cause to seize Atkins for drug possession, Atkins did not make a claim with respect to his seizure for a gun violation under Missouri revised statute 571.030. Nonetheless, Hughes also had probable cause to arrest him for a violation of 573.030. Under the statute, it is a crime to carry a concealed knife, firearm, or any other weapon readily capable of lethal use on about one's person. The prohibition is subject to some exceptions, including instances in which the actor is transporting such weapons in a non-functioning state or an unloaded state where the ammunition is not readily accessible, or when such weapons is not readily accessible, or when the actor has a valid concealed carry permit. And for, let's see here. Here, in performing a pat-down of Atkins' persons outside the car, Hughes felt a gun in a holster near Atkins' waist. The gun was concealed by Atkins' shirt. The gun was loaded. Atkins did not have a concealed carry permit. These facts provide Hughes with probable cause to arrest Atkins for a violation of the statute. Atkins argues that he was free to transport a gun in his car, notwithstanding the lack of permit based on the transportation exception to the statute, and based on he told Hughes so. But the gun did not appear to be in a non-functioning state, and it was in fact loaded. Atkins argues that... Oh, thank you for the subscribe or for the follow there. Dang it! No, where is my dashboard real fast so I can read the name off? Oh, I gotta relog in. Give me a sec. Let's see here, guys. Let's get this loaded. Allow. I knew I forgot something before the live stream came up. Come on, thank you for the follow on Twitch, Letho Boa. Anyway, we'll get back to reading here. Let's see. Let's in fact load. Atkins argues, although the gun had bullets in it, there was no round in the chamber until Hughes drew the slide back, so the gun was not readily capable of lethal use of force at the time he had it on his person. But even if there had been no chambered round, the gun would still have been readily capable of lethal use of force for the purpose of the statute. There is no requirement for the firearm to be loaded or operational for the defendant to be convicted under 57.030. State v. Wright, Missouri, 2012. Citations therein. Atkins also argues that he stepped out of the car because Hughes asked him to, and he did not have sufficient time to tell Hughes about the gun before Hughes detected it. Even assuming Atkins did not have sufficient time, and Atkins otherwise met the transportation exception in the statute to have been carrying the gun in the car, no case addressed such a scenario. Therefore, the contours of Atkins' right would not have been so clearly established that a reasonable officer would have known that Hughes' conduct violated a right of Atkins. Hughes would therefore be entitled to qualified immunity. So the entire case with the firearm and all the whole DUI stop, yeah, the judge said there's no case based off of current and what the law says and all that other stuff, blah blah blah. And I agree with the judge on this case. Atkins should have known better in that situation. Return of the gun to Akins. Akins also alleges his gun was wrongfully held from him on May 9th, 2010 until April 15th, 2013 when he picked it up. Akins does not allege who allegedly wrongfully held his gun, only that it was maintained by the Columbia Police Department. Since the Columbia Police Department is not a defendant in the case, is not a solely entity. See Cartlett v. Jefferson County, citing American Fire Alarm Corporation, something of Commerce of Kansas, 1920. Atkins may be attempting to bring this claim against the City of Columbia. However, the City of Columbia cannot be liable under 1983 on a respondent superior theory. See Manila v. Department of Social Services, 1978. Further, Atkins has not alleged the City of Columbia adopted a policy or had a custom that has harmed him, or nor identified any such policy or custom. The claims fails for this reason alone. Even if Atkins had brought a cognizable claim against the city, it would still fail because he did not suffer constitutional violation. When seizing property for criminal investigatory purpose, compliance with the Fourth Amendment satisfies pre-deprivation procedure due process as well. Rogers v. Knight, 9th Circuit, Rogers v. Knight, 8th Circuit, 2015, which is the prior case that he was involved in, where a retention of evidence is justified by pending charges or an arrest warrant. No further proceedings is required. Likewise, if evidence is needed for an ongoing purpose, a proposed specific investigation, law enforcement authorities are entitled to retain it. Citing Sovereign News Corporation v. United States, 6th Circuit, 1982. Atkins' charges as a result of the May 9, 2010 arrest are not dismissed until November 16, 2010. At the time Atkins' charges were dismissed, no prosque, a prosecutor's formal entry into the record indicating that he will no longer prosecute a pending criminal charge, State v. Belinci, and no prosque result in dismissal without prejudice. Atkins had been charged with a Class D felony, which had a statute of limitations of 3 years. Thus, he could have been recharged until May 9, 2013. Atkins admits the Columbia Police Department maintained the firearm pursuant to the recommendations of Boone County prosecutors. It would have been reasonable for the Columbia Police Department to believe the firearm could have been needed in an ongoing investigation until that time. Atkins' attorney had some communication with Boone County assistant prosecutor about the gun in February 2012. There is no evidence that the assistant prosecutor told the city it would be all right to return the gun at this time. The prosecutor's office did not inform the Columbia Police Department until March 20, 2013 that the gun was no longer needed. Therefore, the seizure continued possession of the property was not constitutional violation because it directly related to a criminal investigation into Atkins for possession of the property. Additionally, following the dismissal of the charges against Atkins, Atkins did not communicate with the Columbia Police Department until October 24, 2012, regarding the return of his gun. This was only after Columbia Police Department discovered it still had the gun and notified Atkins on October 18, 2012 via letter and phone call. Atkins did not arrange for a third party to come pick up the gun and did not contact the Columbia Police Department again regarding the gun until February 22, 2013. Chief Burton was first informed of Atkins' request to have his firearm returned on February 22, 2013. A few days later, Burton asked Captain Jill Schlude to look into it. By March 26, 2013, she had learned that Atkins no longer had a pending felony charge, obtained permission from Boone County Prosecutor's Office to release the firearm, and notified Atkins he could pick up his gun again. Akins did not pick it up until April 15, 2013. Akins has not claimed that the 32 days is a unreasonable amount of time to possess a gun after request for the firearm to return, nor could he make such a claim. Generally, Rogers v. Knight, 8th Circuit, 2015, retention for 3 months after the Supreme Court of Missouri refused to hear an appeal was reasonable amount of time and did not violate the Constitution. Boy. Let's see, continuing on here. B. June 6, 2010, incident Officer Schlude. Akins alleged that Officer Schlude violated his rights on June 6, 2010 in connection with a traffic stop for an illegal turn. Because Schlude took him and his passengers out of his car and made them sit cuffed on the curb while Schlude searched his car without consent or warrant, a police officer may order a person out of an automobile during a traffic violation. Pennsylvania v. Mims, 1977. The Supreme Court has specifically recognized that the investigation detentions involving suspect in the vehicle are specifically fraught with danger to the police officers, and that suspects may injure police officers and others by virtue of their access to weapons, even though they may not themselves be armed. Michigan v. Long, 1983. I think actually these are Supreme Court cases. Some of these are Supreme Court cases. Oh, yeah, it says right here. Supreme Court held that the search of a passenger compartment of an automobile limited to those areas in which weaponry may be placed or hidden is permissible if the police officer possesses reasonable belief based on the specific and articulable facts which are taken together with the rational inference from those facts reasonably warrant an officer in believing that the suspect is dangerous and suspect may gain immediate control of weapons. Additionally, the Supreme Court has observed that during a routine traffic stop, police officers may order out of the vehicle both driver and any passengers and perform a pat-down of the driver and any passengers upon reasonable suspicion that they may be armed and dangerous. Knowles v. Iowa, 1998. Further, even if handcuffing an individual during a traffic stop is not the norm, police officers engaging in otherwise lawful stop must be permitted to take measures including those use of handcuffs they believe reasonable and necessary to protect themselves from harm, or not to safeguard the security of others. United States v. Harvey, and several other citations citing United States v. Coastal Colon, the First Circuit, 1988, just several citations. Akins admits Schlude validly stopped him from an illegal turn. Akins also admits that he had a rifle in the rear of the car and told Schlude about it when Schlude came up to the car. There were 2 other people in Akins' car, including one in the rear where the gun was. Where the gun was. Central Dispatch informed Schlude that Akins was known to be armed and violent, and that the 2 passengers were known to be violent. Akins had a felony weapons charge at the time. Consequently, Schlude was justified in asking Akins to exit the car and performing a protective search of the occupants and the car and securing the occupants during the search. Akins did not suffer a constitutional violation. Akins argues that he felt intimidated by the conversation with Schlude. At the end of the encounter, Akins specifically asked Hughes what the protocol was for such a situation, and he had a gun in the car when he encountered the police. I'm going to take a drink. Schlude said it depended on the officer and gave an example of how he thought officers might react. Schlude had not reacted that way, however. The exchange occurred after Schlude had already performed the search and ticketed Akins. In short, the exchange had nothing to do with Akins' traffic violation and search, but the extent of Akins suggested Schlude had improper motive in conducting the search. The search was objectively permissible, as discussed above, so an inquiry into this motive is precluded. See Smith v. Aldrich of the 8th Circuit, 2000. Okay. The July 27, 2011 incident and Officer Sanders. Akins alleged that he was seized without probable cause by Officer Sanders on July 27, 2011 at Taco Bell, docket 4, page 8. Akins argues Sanders had no lawful basis to perform an investigative stop. Sanders argues the encounter was consensual and Atkins' constitutional rights therefore could not have been violated. Alternatively, Sanders argued that his conduct, a permissible investigation stop, at the minimum, has qualified immunity. Sanders' alternative argument is dispositive. The Fourth Amendment permits an investigative stop of a vehicle if officers have a reasonable suspicion that the vehicle or its occupants are involved in criminal activity. U.S. v. Smith, the 8th Circuit, 2011. In such a case, officers may briefly stop an individual and make reasonable inquiries amid at confirming or dispelling suspicion. Reasonable suspicions require that the officer's suspicion be based upon particular objective facts, which, taken together with rational inference from those facts, reasonably warrant suspicion that a crime has been committed. Graham v. Connor, 1989. The amount of force or coercion used in an arrest, investigative stop, or other seizures is analyzed under the Fourth Amendment objective, reasonable-based standards. The determination of a reasonable suspicion must be based on the common sense judgment and inference about human behavior. See State v. Cortez, 1981. An individual's presence in an area of suspected criminality standing alone is not enough to support reasonable particular suspicion that a person is committing a crime. Illinois v. Wardlow, 2000. But officers are not required to ignore relevant characteristics of location, determining whether circumstances are sufficiently suspicious to warrant further investigation. And this is where this is going to get really interesting from just reading so far. Thus, the fact that the stop occurred in a high crime area is among the relevant contextual considerations in a Terry analysis. The Supreme Court has also recognized that nervous, evasive behavior is a pertinent factor in determining reasonable suspicion. For example, once an individual is aware that police are behind him, his choice of circular route or driving with no apparent destination may strike a trained officer as a similar attempt to avoid police attention. Hoover v. Welsh, out of the 6th Circuit, 2012. When used by trained law enforcement officers, objective fact, meaningless and to the untrained, can be combined with permissible deductions from such fact to form a legitimate basis for suspicion of a particular person for action on that suspicion. United States v. Cortez. Thus, Wardlow, for example, the fact that the defendant was present in an area of a heavy narcotics trafficking and fled from the police without provocation justified an investigative stop. In Hoover, an investigative stop was justified when the defendant was driving a car filled to the brim with piles of clothes and other personal items, apparently traveling randomly, while police were following him through a neighborhood known for theft and property crimes. Here, Akins pulled the car out of a high-crime neighborhood. Sanders began following the car and observed the driver begin acting in what he believed an unusual manner according to his training and experience. The driver was trying to avoid police contact. Sanders saw an occupant shining a light from the rear window that had been recently trained that individuals will use phones or cameras or to video record police to try to deter contact. Here, let me scroll this down here. Contact by the officers. When the driver parked, Sanders observed that the occupants were watching his car. Sanders spoke with the occupants, checked their identification, returned it. The interaction lasted less than 2 minutes. Sanders never drew his weapons, activated his lights and sirens. He contacted Joint Commission and said he was performing a subject check and got the information on the plates, car driver, and occupants. The objective facts taken as whole reasonably warranted a suspicion of criminal activity. At a minimum, a reasonable officer would not have known under the circumstances that his conduct was unlawful. Akins cites a case in which investigative stops were held unreasonable, but not factually similar to a case before the court in the United States v. Camacho, the First Circuit, 2011. For example, the defendant was simply walking normally in a residential neighborhood, displayed no apprehension or nervousness when the officers approached him, and gave direct, non-evasive answers to the officers. In the United States v. Celbellus, 2nd Circuit, 1981, the officers blocked the defendant's car and approached him with guns drawn without any reason. The case here involves facts, those in Wardlow and Hoover, that they permitted the brief investigative stop rather than the facts that those in Camacho and Celbellus. Yeah, Sabellis that did not. Sanders did not ask for any many as 2 backup officers and a police dog. And even if Officer Hendricks and Parsons did block Atkins' car, nothing in the record shows Sanders asked them to do so. Sanders is not responsible for the other officers' actions. Atkins further argues that in absence of a valid reason for investigative stop, Sanders was stopping him because he had been filming Sanders earlier. Atkins points to a report of an investigation by Columbia Police Department Internal Affairs, concluding Sanders had violated police department guidelines that required seizure of persons to confirm the limits of the Fourth Amendment as interpreted by the judiciary. Atkins relies on Fed R Evidence 803, subsection 8A, which allows evidence of factual findings from legally authorized investigation, but conclusion concerning whether the police officers conduct conformed to the limits of the Fourth Amendment as interpreted by the judiciary is not factual finding. It is a legal conclusion and inadmissible hearsay not covered by FRE 803, Sullivan v. Dollar Tree Stores, the 9th Circuit 2010. Pure legal conclusion are not admissible as factual findings in context of summary judgment motion. A conclusion of law by third-party investigators does not by itself create a genuine issue of material fact for obvious reasons that legal conclusion is not factual statement. Hines v. Brandon Steel Docks Incorporated, the 11th Circuit, 1989, Rule 803-8C, does not provide for admissibility of legal conclusions contained within an otherwise admissible public report, also part from the FRE 803 issue. The 8th Circuit has held that the legal conclusion of expert witness on police conduct are not admissible. So this is that whole, the cops can use hearsay against you, but you can't use hearsay against the cops. Schmidt v. City of Villa, 8th Circuit 2009, expert testimony on reasonableness of police behavior in light of the Fourth Amendment standards as statement of legal conclusion not admissible. Citing Pearson v. City of Plymouth out of the 8th Circuit 1985. Any event this march of an investigative stop was subjectively permissible, as we discussed above. An inquiry into the motive is precluded. See Smith v. Aldrich. Sanders is entitled qualified immunity with respect to the July 27th, 2011 incident. And boy, that was quite the mouthful right in there. Now, we still really haven't hit. And I see you guys are having fun with the chat there and putting in quotes. We're starting to get close. Oh, and how far are we? Let me move my chat box here. Oh, we're getting close. We're about 2/3 done with this. Akins alleges his rights were violated by Officer Palmer. Well, it looks like typo. Probably Officer Palmer. On September 11, 2012, when Palmer stopped him for a traffic violation, arrested him on a number of charges to which were eventually dismissed. Palmer stopped Akins because Palmer was driving through an intersection and Akins entered it, failing to yield to the right-of-way. Akins did not have driver's license. He told Palmer that he was driving to a citizens justice-related event and was therefore covered under his limited driving privileges. But when Palmer ran Atkins' name through the mules, Atkins' driving privileges was reported as revoked without any limited privileges. Atkins could not provide proof of insurance. Palmer arrested Atkins for driving without while revoked. Palmer's had probable cause to stop Atkins and arrest him for this violation. In conducting a search of the incident arrest, Palmer found a butterfly knife in Atkins' right front pocket. Based on his training and experience, Palmer knew a butterfly knife was a type of knife which could be which the handle is hollow, split into parts, and connected the blade with 2 loose pins. To open a butterfly knife, the blade pivots and the pins in an arc. Based on his training, the police academy knowledge, and police experience, Palmer knows that a butterfly knife can be opened one-handed by the operation of a gravity or the application of centrifugal force. In addition to driving and insurance violations, Palmer was arrested for Atkins for unlawful use of possession of a prohibited weapon under the Missouri statutes 571.020 and 571.030. Prior to submitting the probable cause statement, Palmer checked with a supervisor about the butterfly knife. The supervisor told Palmer the knife was illegal. Palmer wrote the probable cause statement that the knife was designed to be opened from one hand by gravity or by application of centrifugal force. In May 2013, charges were amended to driving while revoked or suspended, failure to yield right away. Akins alleges the violations cited in the probable cause statement have nothing to do with the butterfly knife, and his knife and the knife was legal. The Fourth Amendment violation can occur as a result of officer's probable cause statement if the probable cause statement contained deliberate falsehood or other acted with reckless disregard for the truth when he prepared it. Murray v. Lane, 595, 8th Circuit, 2010. Under 571.010, a knife is a dagger, dirk, stiletto, or blade, or bladed hand instrument that is readily capable of inflicting serious physical injury or death by cutting or stabbing a person. For the purpose of this chapter, knife does not include an ordinary pocket knife with no blade more than 4 inches in length. Under 571.010, a switchblade knife is any knife which has a blade that folds or closes into the handle or sheath and that opens or releases from the handle or sheath by force of gravity or application of centrifugal force. First, Officer Palmer is entitled qualifying immunity regardless of whether the butterfly knife is found on Akins qualifies a knife under 571.010. Qualified immunity is appropriate if the defendant hasn't accused of submitting recklessly false affidavit, and if the corrected affidavit would still provide probable cause to arrest or search. Bagby v. Borneham, 8th Circuit, 1996. Since Akins was also properly arrested for driving while revoked, Palmer's probable cause statement provided sufficient probable cause for arrest regardless of any reference to the butterfly knife. Further, Officer Palmer would still be entitled to qualified immunity even if the arrest was solely based on the butterfly knife. Arguably, under 571.010, the knife Akins was carrying was a switchblade knife. The butterfly knife had a blade that would fold into its handle. Based on the training and experience, Palmer testified that the butterfly knife could be opened by gravity or centrifugal force. Before finishing the probable cause statement, Palmer also checked with his supervisor whether the butterfly knife was legal. It was told it was not. At that very least, a reasonable officer would have concluded the butterfly knife was a switchblade knife and illegal under the statute. Akins' argument or belief that the latch would make it difficult to open the knife by gravity or centrifugal force at most makes the application of the statute to the situation debatable, which will no defeat qualified immunity. Further, even if the knife had a switchblade was not a switchblade knife, Palmer would still be entitled to qualified immunity because it was not clearly established under Missouri law what constitutes the blade of a knife and what would have been reasonable for him to conclude the butterfly knife blade was at least 4 inches for the purpose of 571.010 definition. No Missouri case defines blade or indicates how a blade of a knife should be measured to determine its length. The state of Missouri has previously defined a weapon's blade as metal part of the weapon. The state v. Lurker, where the state defined all blades as a metal round shaft, it is logical to read that the statute to refer to a metal shaft protruding from the handle when referencing a blade. Because the metal part attached to the handle that gives the weapon user ability to reach and injure a victim, measured from the tip of the blade to the bottom of the hinges of the metal part of the Akins butterfly knife, is at least 4 inches. At the very least, the law regarding 571.010 and the term blade is not clearly established, and Palmer is entitled to qualified immunity. For the first time in his suggestion in opposition to the defendant's motion for summary judgment, Akins states that his butterfly knife was unlawfully destroyed. Uh-oh. It looks like the judge found something to actually do hit him on. Docket 104, page 37 of 46. There is no such claim in his amended complaint, no such claim that is not properly before the court. Moreover, the facts in the recording show it was destroyed, or who allegedly did so, let alone a defendant did. The respondent superior is not basis for a 1983 liability. Keeper v. King, 8th Circuit, 1997. Ah, damn. Also, for the first time in his suggestion, Akins states the City of Columbia violated his due process rights by failing to follow the Missouri Criminal Asset Forfeiture Statute 513.60 to 45 in handling the butterfly knife. Akins' amended complaint contains no Missouri CAFA claim, so such a claim is not properly before the court. Any evidence of Missouri CAFA does not apply to this case. It's discretionary civil asset forfeiture procedure that the prosecution may employ, and nothing in that statute affects the law enforcement ability to seize property pursuant to the criminal investigation. See Missouri Revised Statute 513.607. Atkins' lengthy argument that the law should not be construed to provide prosecution with absolute and unfettered discretion to retain property does not address the facts of this case. The defendant is not the defendants are not prosecutors and would not be liable under 1983 for the prosecutor's exercise of discretion concerning retention or civil forfeiture of property. So, in this, at the end of this, the judge sat there and stated, "Well, the officers entitled to qualified immunity on this stop. It pretty much, when we look at it, everything was done legally. But for the first time, so far that we have pointed out in this case, Akins does have a legitimate claim against the police department, but that claim is not properly lodged against the police department in the court documents, and that is underneath the asset forfeiture. So right there, as in Vicus, it's blatant theft, because it was improperly destroyed. They didn't go through the proper methods of doing that. Okay, alleged retaliation by the City of Columbia. Akins alleges the City of Columbia has a pattern and practice of targeting those critical of police misconduct with retaliation action. And this was he was targeted with a wanted poster displayed in the Columbia, Missouri Police Department for exercising his First Amendment rights, docket 4, page 30 of 40. The creator of the poster is unknown, and the City of Columbia cannot be liable for the poster or any alleged retaliatory behavior under 1983 on a respondent superior theory. See Monella v. Department of Social Service, 1978. The municipality may be held liable for unconstitutional acts of its employees when the acts implemented or executed an unconstitutional municipal policy or custom. See Doe v. Washington County of the 8th Circuit, 1998. But to establish municipal liability, a plaintiff must prove that a municipal policy or custom was the moving force behind the constitutional violation. Monella, citing Monella, see also Board v. Combs v. Brown, 1997, holding that only a deliberate action by the municipality can meet the moving force requirement. Akins neither alleged nor demonstrated the City of Columbia adopted a policy that led to the poster and the alleged retaliation. The claim concerning the poster and alleged retaliation fell for these reasons alone. Furthermore, the First Amendment retaliation claims, among other things, proof of a defendant's retaliatory animus, which need not necessitate to be a sole motive, must be a substantial factor in the plaintiff's subsequent injury. Bryberry v. City of Minneapolis, 596, out of the 8th Circuit, 2010. There is no evidence in the record of motive of the person who created it, let alone that a retaliatory animus on that person's part was a substantial factor in the subsequent injury of Akins experienced in any case. In support of his retaliation claim, Akins points to the May 19th, 2010 Akins stop by Officer Quintina. But Quintina had probable cause to stop Akins because Akins' windows tint appeared to be darker than legal limit and was driving a car with expired plates. You're not helping yourself with that, so just keep in mind, if you're already breaking the law with expired plates or something like that, it opens the door for other things, and it becomes really hard to argue a case. And that's one problem with Akins. A lot of the situations he finds himself in with the police, he sort of has already opened the door either through through the situations he put himself in by doing something a little bit shady, or just outright pretty much breaking the law. Quintina also had a probable cause to arrest Akins because of 2 active warrants. Moreover, Quintina is not a defendant, and his actions cannot be imputed to defendant to a defendant here. Personal involvement is required to establish a liability under 1983. Beck v. Lafar, 8th Circuit, 2001. Quintina's actions do not establish retaliation on part of the defendants. Akins also points to 2 incidents involving policing at downtown bars at closing time. Officer Corcoran, who is not a defendant, and Hughes' encounter with Akins in public 2 separate times in October 2011. While patrolling, Missouri law requires bars to be closed and locked and empty of patrons after 1:30 a.m. or be fined, according to Missouri Statutes 311.290. The Columbia Police were using a spotlight to view the bars, disperse crowds, and stave off fights and loitering by intoxicated persons in routine practices. Hughes was shining a spotlight at the bar Akins was in near 1:30 a.m., saw someone in the bar, and he went to tell the bar employee to clear the bar or be fined. Akins was working there as a videographer at the time. There was no evidence in the record showing Hughes knew the person he saw from the car was Akins, nor that he knew Akins was employed by the bar, not a patron, when approached by the bar employee. Given these facts, Akins failed to show Hughes a threat. Hughes' threat to fine the bar employee for having an individual in the bar after hours was anything other than routine law enforcement. Further, Akins later voluntarily walked up to Hughes outside the bar. Hughes arrested him because he had outstanding warrants. See? Warrants opens up the door for being arrested, not retaliation. Officer Corcoran was shining a spotlight on a crowd of people leaving the bar, including Akins. By Akins' admission, he and his brother broke from the crowd and began walking sideways across an adjacent lot to show that they were being followed by the spotlight. Police officers are allowed to make observations while they're in public. See journaling. Florida v. Riley, 1989. Wait. Is it? Didn't I do a cover on this thing stating that that was the airspace one? Dang, why is this not copying right here? Florida v. Riley. Is this... let's see here. Copy this. Let's just do a quick search. I could have swore I for the Supreme Court case held up. Yeah, I knew it. Yeah, so they used the airspace case in this this argument. That's sort of funny. California v. Carscalo, 1986. Nothing in the record shows that Carscalo knew Akins. That the officer might have been curious about 2 people who broke from the crowd and began walking sideways across an adjacent lot does not demonstrate retaliatory motive. In short, the bar encounters do not establish retaliation on the part of any of the defendants. Akins also argues that he was retaliated against when he was stopped from filming a citizen and police department lobby in 2011. His links to Citizens for Justice page were removed from the police department's Facebook page in the summer of 2011. And he was excluded from police department media training day in 2015. None of these individual defendants participated in these incidences, and as discussed above, the city cannot be held liable under 1983 on a respondent superior theory. Moreover, Akins points to no unconstitutional municipal policy or custom. Further, he has no constitutional right to videotape any public proceedings he wishes to. See Rice v. Kemper K of the 8th Circuit, 2004. And this is where we're going to start getting into the messy stuff. And after I finish this, we're going to come back and we're going to be looking at the citations and go over my specific posting from 7 months ago about what this covers and why it doesn't. It's not what people make it out to be, and why I'm in agreement with the the Student Press Law Center here. Neither the public nor the media has a First Amendment right to videotape, photograph, or make audio recordings of the government proceedings that are by law open to public. And Wisconsin and Scholastic, what is it? Man, I'm drawing a blank here. 17 out of the 7th Circuit. This specific case deals with A Student Athlete Association. That's what it is. Interscholastic Athlete Association up in Wisconsin. His links to the police department's Facebook page were treated as same as everyone else. There was no constitutional right to unlimited posting. See Tinley Sparks Incorporated v. Ville of Tinley Park, May 11th, 2015. Plaintiffs do not have not cited any case holding that they have a right to post messages that could be perceived as political in online forums intended to promote small business growth. Indeed, the cases support opposite conclusion that defendants could, consist with the First Amendment, prohibit political messages on downtown Tinley website and Facebook page to preserve the intended purpose of small business forums, so as long as they refrain from engaging in viewpoint discrimination. Finally, with respect to media training event, Akins was not a member of the traditional media, nor does he have records show an active non-traditional media member at the time. Space was limited. These were content-neutral reasons not to contain an exception for Akins to attend the invitation-only event. The media does not enjoy the right to equal access or special First Amendment rights. See Snyder v. Riggold. The retaliation claim therefore fails. So, we're going to come back because this is the core crux of the First Amendment argument of can't record police, blah, 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 and all that other stuff. Or, well, part of their core crux. And, yeah, we're getting pretty close here to finishing this up, so let's get back up. Failure to train. Yeah, 007, the media does not enjoy the right of equal access. That is very true. And I'll actually do further explanation on all that stuff. Failure to train. Akins broadly alleges that the City of Columbia failed to train its law enforcement officers, docket 4, page 35 of 40. A municipality cannot be liable under 1983 for failure to train or supervise its police officers, and the police officers did not commit a constitutional violation. Gibson v. Cook, the 2004 8th Circuit case. Police officers were not held liable for constitutional violations because they have probable cause. The city, therefore, cannot be subject to liability under 1983 for failure to train and supervise, citing Moore v. City of Dislodge. As discussed and above, defendants Hughes and Schlude, Sanders, and Palmer had probable cause in connection with the incidents of May 9, 2010, June 6, 2010, July 27, 2011, and September 11, 2012. Furthermore, Akins cannot demonstrate his constitutional rights were violated in connection with the return of the gun, seizure of the butterfly knife, and the reporting of the activities. Further, the train claim therefore fails. G. Malicious prosecution. Akins alleges he was subject to malicious prosecution. Underneath docket 4, pages 33 through 34, a claim of malicious prosecution does not appear actionable under 1983 in the 8th Circuit. See Kurtz v. City of Shrewsbury, 8th Circuit, 2001. Moreover, the court has uniformly held that malicious prosecution by itself is not punishable under 1983 because it does not allege constitutional injury. See also Trevino v. Benton County, the 8th Circuit, 2004, citing Kurtz with approval. But even if the 8th Circuit recognized such a claim under 1983, Atkins' claim would fail at a minimum because the existence of probable cause for his arrests and discussed above would defeat it. See Faganin v. City of Lino Lakes, Minnesota, 8th Circuit, 2004. Probable cause supporting warrant and arrest would defeat a 1983 claim of malicious prosecution. Conspiracy. Akins alleges defendants engaged in conspiracy to deprive him of his constitutional rights, docket 4, page 35 through 36. To prove a 1983 conspiracy claim, a plaintiff must show 1. Defendants conspire to deprive him of his constitutional rights, that at least one alleged co-conspirator engaged in an overt action furtherance of conspiracy, and 3. The overt act of injured plaintiff. Askew v. Miller, 8th Circuit, 1999. Most importantly, the plaintiff is required to prove deprivation of constitutional right or privilege in order to prevail on a 1983 civil conspiracy claim. As discussed above, Akins failed to prove he suffered a deprivation of constitutional rights. Furthermore, He has not presented any evidence of defendant's reach of an agreement to deprive him of his constitutional rights guaranteed. Larson by Larson v. Miller. Therefore, the conspiracy claim fails. Conclusion. Defendants Burton, Hughes, Sanders, Slood, Palmer, and City of Columbia motion for summary judgment, docket 81, is granted. Plaintiff Akins' motion for summary judgment in part of docket 91 is denied. And that is quite a lengthy thing. But, as is, we can see that this case is very well written, in my opinion, by the judge. Tons of citations, tons of references to a standing case law. And this is, remember, this is the district case. This covers only the summary judgment that was played at the district level. This is not case law. When it was appealed, what was appealed was motions to the 8th Circuit, not the specific arguments that were made in this case, because they wanted to go through to a different judge and all that stuff. So we got all that sort of lined out, and I'm going to go ahead and I'm going to read through my posting here about the issue in when I did my research back on this 7-8 months ago. I have not read Pledford, Fay, and Core v. Mayor and Alderman City, Savannah, 007. I'm not actually specifically familiar with that one. I'm only familiar with like certain specific big cases off the top of my head, and I mean I'll read smaller cases like the one over in the Supreme Court of Hawaii with the right to film police, or no, was that the film police? Yeah, I think that was the right to film police thing. And even then, that it's going to be hard because I have to sit down, read these, and maybe do some subsequent follow-up research, and then I come back and read it to you guys. Yes, and yeah, the federal judicial system has consistently upheld qualified immunity many times. Qualified immunity is a constant pain in the butt for a lot of people. I'll see about checking it out. Okay. Ever since the KRCG came out with an article titled 8th Circuit Citizens Do Not Have a Right to Film Public Officials, we have been seeing police starting to try and use this method to shut down people who are filming this month. I showed you the two examples. This has been refuted by both the National Press Photographers Association and the Student Press Law Center, but they don't really get into the finer details of the subject at hand. I will now clear up the details on this issue and explain why the KRCG is wrong, along with anyone else that is trying to use this case to block the act of filming of police. First off, the appeals case of Akins v. Knight was about judicial procedure of the district court case. If you read through the actual case, you can see it nowhere takes into consideration about the issue of filming, but on the issue of the motion that was filed by Akins. When the court case happens, there are many things that can end up being appealed, ranging from how evidence is provided to the certain procedural motions that won't be considered for case law. Won't be considered for case law. We see this happen often when people are trying to bring up changes in evidence or new information that may impact criminal cases. These citations refer to district court case deals with special time, place considerations, and not public filming of police. The district court case deals with Akins trying to film inside a police station and media training day. The court specifically cited, moreover, Akins points to no unconstitutional municipality policy or custom. Furthermore, there is no constitutional right to videotape any public proceedings he wishes. See Rice v. Kemperker, 8th Circuit, 2004. Neither the public nor the media have a First Amendment right to videotape, photograph, or make audio recordings of government proceedings that are by law open to the public. This is basically stating there are time, and place restrictions when it comes to certain filming situations. And both police station and media training day are most likely falls under those situations. When you look at Rice v. Kemperker, it is a case of a person wanting to document an execution of Daniel Basil using a camera. The court makes the argument that the execution chambers falls under time, place, and manner restrictions, much like the court rooms and jails. and majority of case law citations refer to the court opinion are often specifically about jails and courtrooms, except for one case. Instead, courts have universally found restrictions on videotaping and cameras do not implicate First Amendment guarantee of public access. See Whitland Woods v. Township of West Whiteland, 3rd Circuit, 1999, holding public has no right to videotape planning commission meetings that were required to be public. When you dig into Whiteland Woods v. Township of Whiteland, you find that once again it is about time and place considerations, much like the Rice and v. Kimmerker, and of the citations and court opinions follow suit. Now I want to add one last note. The district court also refers to Wisconsin's interscholastic I'm losing track of my thoughts here. Not authority. Athletic Association, v. Gannett, a 7th Circuit. When we're talking about the issue of recording, but when you look into specifically at the case, it deals with the state agencies giving exclusive broadcasting rights of the sporting events. It also covers time, place, and restrictions, but goes further stating, for example, the distinction between coverage and transmission of an entire event is also important in a case involving the right to public access. In these cases, public and media often have a right either by statute or even the Constitution, see Richmond newspaper, Incorporated v. Virginia, 1980, to attend a public proceeding like an execution or trial. Although there may be an affirmative right to be present, the Supreme Court has not yet recognized any corollary right guaranteed by the First Amendment entitling media to record, let alone broadcast live, what happens at the proceedings. See Rice v. Kimmerker, 8th Circuit, 2004. Neither the public nor media has a First Amendment right to videotape, photograph, or make audio recordings of government proceedings that are by law open to the 7th Circuit, United States v. Curley, 7th Circuit, 1985, holding that public has no First Amendment right to videotape a public trial, despite the fact that Richmond newspaper guarantees the right of access. So we can finally take from these events that you are, if you are out filming in public in the 8th Circuit Court of Appeals states, you have the legal right to film police in public and from your private property. The inside of a police station, on the other hand, might fall under time and place restrictions, but that is for another day and a different court battle. That is pretty much my overview. And I sat down, every single one of these cases, I sat down and dug into them that I cited, looking into this. That's what you sort of need to do to get a broader understanding of what's going on. And this is the reason why it's considered a misunderstood case. Now, I can see why Akins' lawyers made the arguments. They're trying to get this pushed higher up in the higher courts. They're trying to get, they're trying to win the case. By any means legally, pretty much by any legal proceedings they can, position they can push. Now, when it comes down to it, when you really read the nuts and bolts, like me and the other two agencies, here, the Student Press Law Center and the National Press Photographers Association, we see it as just being an issue dealing with emotions of doing an appeal about a district case. And even then, the district case does make some troubling findings on the time, place, and manner restrictions, but it is not case law precedent. It just sort of starts a slippery slope in that kind of direction. What's it? The fact that you're trying to make a recording of anything in public is illegal is disturbing. I sort of agree, Leviticus. Open public meeting law could be used to fight no filming in court. There aren't any laws against filming in court. It's up to the presiding judge. It's a policy. Yeah, and the whole courtroom aspect is the no filming in a public court setting is a big issue. It's been fought several times, and actually they make reference to that with the Curley case, United States v. Curley. I think I read that one too. I can't remember off the top of my head. I'm probably going to go back over it. But eventually what I'm going to do is all these cases where time, manner, and place restrictions have come into play, I'm going to sit down and read those cases, because those are important cases to get a further understanding of where the limitations come with filming, which is something that a lot of the people that are in the First Amendment testing and auditing community need to have a better understanding. Let's see, open public, let's see, when SCOTUS allows you video broadcasting in the courtroom, all others will. The Ninth Circuit allows filming. I'm not sure about in the courtrooms and stuff like that. It's still dependent on the policies for that. But yeah, as is, we've already got several cases which, case laws established. Third Circuit, First Circuit, Fifth Circuit, Ninth Circuit, I think it's the 11th Circuit, and so forth, so forth. That I think I've covered ad nauseum and all that stuff. And how long have I been live streaming here? Boy, we just passed the 2-hour mark, so this is going to take over a day to properly render. Ninth Circuit Court. Ooh, okay, so okay, I'm going to check this out. Also the Ninth Circuit Court of Appeals, they actually live stream quite a few of their cases. So let me take a look at your citation 007. Let's see. U.S. Court of Appeals, Ninth Circuit requires appeals for the Ninth Circuit media coverage of legal matters. In almost all cases, oral arguments before the appellate court are open to press and public. In certain high-profile cases, the court may reserve courtroom seating for media reporters. Should contact the court to determine and reserve. Ninth Circuit Court of Appeals. Oops. Oh, you know what? Why am I'm reading this in the wrong spot. Let me bring this up. I'm sorry, guys. I'm being a bad host here, and I'll start reading it over from the start. The interest in informing the U.S. Informing the public, the U.S. Court of Appeals and the Ninth Circuit media coverage legal matters. In almost all cases, oral arguments before the appellate panel are open to press and public. In certain high-profile cases, the court may reserve the courtroom seating for media. Reporters should contact the court to determine whether reserved seating is available. The Ninth Circuit Court of Appeals is one of 2 federal appellate agency courts that regularly allow still video cameras and audio recorders in the courtroom for the purpose of reporting and proceedings. Rules pertaining to the use of these devices are explained in the court guidelines for photography and recording and broadcasting in the courtroom, which includes the camera request form. Opinions will generally be displayed on the website by 10 a.m. Pacific time frame. Memorandum disposition by 1 p.m. Pacific time on the day of filing. The court uses electronic case filing ECF system, which makes docket information available and other documents available via the internet. A PACER account will be necessary to access these files. For more information about the acronym for public access to court electronic records, click here. And of course, here's their camera guideline, which got to be saved and all that fun stuff. So we'll look at that. And then NJ Diver, you're throwing me another citation. Yeah, and that specifically covers the courtrooms themselves. And boy, you guys are... okay. I like this. Okay, NJ Diver, I'm definitely going to show this one. Paste and go. The Fourth Amendment, where know your rights. Who came up with that one, NJ Diver? I'm very curious. And, oh, this is another interesting thing. Let's see. Cargo Collective Fourth Amendment. Let's take a look at this one together, guys. Let's see. Only boots have been properly licked. May have public access. Yeah, well, the lower courts, they're when it comes to actual, like, certain kinds of trials, there is a reason why there's a limit on that stuff. Okay, I did not copy paste the right link here. Let's see here. Let's try this again. Paste and go. Wait, what? Oh, it came from this page. I see. But it keeps loading. Oh, let me see here. It's because I got this script blocker, that's why. And let me turn that off. That probably helped. Come on, load it up. Okay, shield's down. We'll see if that fixes it. Brave is still an under development. How should I put it? Program here. Cargo tools. Okay, this is not what I was looking at a minute ago. What the hell? Let's try this again. Let's give me a second here. I think probably what happened was it just I had the. Yeah, it's just not loading right within Brave, so I'll look at that a little bit later. It looks like it's got some interesting stuff. So this is so important what you do, BB, along with these knowledgeable people in the chat, such as much. Yeah, that's the whole point. A lot of my stuff is very dry when it comes to these things, and that's part of the reason why I try to liven it up with my channel with some coverage of like the blood sports stuff that I go and do where I'm arguing these topics. But I hopefully this was quite the educational thing. I might actually do a cut where I'm going over these, so this way they're like individual videos so people can actually understand it. But this is just, you get a great idea of what is all the 8th Circuit. And there was a lot of misinformation, a lot, not just from people that are involved in the lawsuit itself, but also from the people, police officers that were trying to cite it. It's your car. It's your karma. Okay, NJ Diver. Well, wait. Is this site ran by you? I'll have to check this out. It says it's Los Angeles, California, and you're over in New Jersey, so. Let's go ahead and get my OBS back up here. Transition is back. But any other thoughts, comments, questions that I might be able to ask, or answer on this stuff before I get up and continue on with my day and make phone calls and all that other stuff. Filling the dead air here. This is the shitty part. I don't have a co-host. Constitutional Supreme Court rulings, appeals court rulings are instructional manual. Read it, learn it. Yep. Unfortunately, there's just way too many for everybody. Please post the URL of the article. Which article, though? The one that you sent me? Or, oh, well, I'll just go ahead and post those real fast. I'll update the description with what you gave me. Just found it. Okay. I'll add in the extra citations here. And then the other one. There we go. Added that in. So those citations, they're going out across the collective chats. Oh, you're referring to the one on the case. Oh, okay. Give me a sec on that. I'll go ahead and get that posted up for you. But all those citations are actually within the in the main citation of the Reddit there, so you can see it. There's the KCRTG that's coming to you, and then here's the other one by the legal group there, the students, which is what was it? Student Press Law Center. So that's all gone out across the multiple boards, and I think my the chat thing is sure probably getting spammed like crazy, I suspect. On all of that. But as is, in the description of the video itself, is the main, like, am I free to go Reddit posting where you can go and read and see all the citations and the follow-up citations and all that stuff. But I think I'm going to go ahead and call it end of a stream. I got stuff to take care of and try to get out and get a haircut done today, hopefully. And I hope you guys had an enjoyable opening morning with all this. Oh, I'm going to have to check that one out. Anyway, I'll talk with you guys later. I might have another live stream up later with me tinking around or something like that on my other channel. Or I might be doing some more drama stuff. Just getting clips out there from the Baked Alaska stuff, which is still, it's on its downhill peak. It's quite interesting. Damn it, Panda, I don't care about that. Anyway, you guys have a good night, and well, I mean, not good night. Have a good day, and I'll see you around.